Good evening, friends. So, we shall begin our discussion on Transfer of Property Act from the portion that we finished last week. And we are supposed to discuss very important provisions today, that is, Section 13 and Section 14, which says, which talks about right of an unborn person and rule against perpetuity. These are two very important rules that have been narrated in Section 13 and Section 14 of TPA Act, and very important for the purpose of examination as well, because I believe most of the times a question from that person is asked, and even if uh, you do not prepare it for the sake of examination, then also it is important because it is a very important rule of Transfer of Property Act. So without wasting time, let's proceed to our discussion today. What's this? I couldn't uh, create the slides. I've just prepared the notes but couldn't create the slides. I hope it is visible to you still.
Yes, sir.
Okay. So, coming to section 13, which is talking about transfer for benefit of unborn person. So basically हमको जानने को पड़ेगा कि ट्रांसफर ऑफ प्रॉपर्टी एक्ट ର मेन पर्पस इज टू डील विथ ट्रांसफर बिटवीन लिविंग पर्सन्स. डील कौन करूची लिविंग पर्सन्स को भितर ट्रांसफर को डील करूची ट्रांसफर ऑफ प्रॉपर्टी एक्ट. But then section 13 is like an exception. Why? Because you are hereby transferring a property to a person who is not in existence. जे कि एपर्यंत born ହେଇନି ତା फेवर रे आपण ट्रांसफर करछंती. दो ट्रांसफर ऑफ प्रॉपर्टी एक्ट talks about कि only it should be between persons living, but here you are by transferring a property to a person who is not in existence. But how it will be done? There are certain conditions which are to be strictly fulfilled in order for that to happen. That अपन unborn person को transfer करियार right तो दे देला अपन को. Because हाँ अब दरकार पड़ी पारे कि that ମୁଁ ମୋର ଛୁଆ କୁ କି ମୋ ନାତି କୁ କି କାହାକୁ ଗୋଟେ ମୁଁ transfer କରିବାକୁ ଚାହୁଁଛି, and for that purpose law gave that right that you can transfer a particular property to an unborn person, but of course on fulfillment of certain conditions. Probably this is the only exception where you can transfer a property from a living person to not a person who is to a person who is not living right now. So in this section, what is done that uh, an interest is created in favor of an unborn person. So basically, here you are transferring the property to an unborn person, and while doing so, you are creating prior interest. Why the same transfer prior interest? Because again, why you have to create prior transfer? Though law allowed that, law allow kala na ଆପଣ unborn person को transfer କରିପାରିବେ, but if you ask me, I'll say no, law probably still did not allow. law କହିଲା କି ଆପଣଙ୍କୁ କାହାକୁ ଆଗ ଜଣକୁ transfer କରିବାକୁ ପଡିବ, ତା ତା ମାନେ ଜଣଙ୍କ ଫେଭରରେ ରଖିବାକୁ ପଡିବ ଯେପର୍ଯ୍ୟନ୍ତ ସେ unborn person ଟା existence କୁ ଆସିନି. ତ ତା ମାନେ ଆପଣ ସିନା ଆପଣ ଟ୍ରାନ୍ସଫର କରୁଛନ୍ତି, ultimate beneficiary unborn person ହେଲା, but the property is not kept at abeyance, because the rule that that is there, that is the property cannot be held in air. ଯଦି property को ଆମେ ଗୋଟେ unborn person को transfer କରିଦେବା directly, then that means କି ଏବେ ମୋ ନାଁରେ ଅଛି, ମୁଁ transfer କରିଦେଲି ଯେ ମୁଁ ଆଜି କହିଲି for example ମୁଁ କହିଲି କି ଆଜିଠୁ ମୋର ନାତି ଯେ କି ଏପର୍ଯ୍ୟନ୍ତ ଜନ୍ମ ହେଇନି, କାହିଁକିନା ମୋ ପୁଅ ବି ଜନ୍ମ ହେଇନି, ମୋର ନାତି ଯେ କି ଏପର୍ଯ୍ୟନ୍ତ ଜନ୍ମ ହେଇନି, ମୁଁ ତା ଫେଭରରେ ଟ୍ରାନ୍ସଫର କରୁଛି ଆଜିଠୁ. ସେ ଯୋଉ ରେକର୍ଡ ଅଫ ରାଇଟ ରେ କାହା ନାଁଟା ଲେଖା ହବ? କାହା ନାଁ ତ ଲେଖା ହେଇପାରିବନି. ତାମାନେ ପ୍ରପର୍ଟିଟା କଣ ଗୋଟେ ଉଡିକି ରହିବ? ପ୍ରପର୍ଟି କଣ ଏୟାର ରେ ରହିବ? ୟୁ କାଣ୍ଟ ଡୁ ସୋ. So you have to create prior life interest in between. କି ସେଇ ନାତି ମୁଁ ଏମିତି ଟ୍ରାନ୍ସଫର କରିପାରିବି ଯେ ମୋ ପୁଅକୁ ପୁଅର ପୁଅର ଡେଥ ପରେ ମୋ ନାତିକୁ ସେମିତିଆ କରିପାରିବି. कहीं इन द मीन टाइम मो पुओ ट्रांसफर होगी रेकॉर्ड ऑफ राइटर से पुअर ना रही परियो तो सेठी दिस इज व्हाट इट सेज दैट while you are willing to transfer a property to an unborn person you must do follow these two rules, that is you have to create prior interest in favor of other person, but while transferring the said property to the unborn person you must absolutely transfer the remaining interest. That means example देले आपण बुझी परिबे मु सही ये एग्जांपल रे मु मोर पुओ को ट्रांसफर कली आग पुओ को लाइफ इंटरेस्ट क्रेडिट कली पुओ फेवर रे अल्टीमेट बेनिफिशियरी रखिली नाती को कहली पुओर डेथ परे मोर नाती को जीवो मु सेठी नाती को जतले जीवो जे कि अनबर्न परंत अछि सेठी मते एब्सोल्यूट ट्रांसफर कर परिबो सेठी मु कहि परिबिन जे नातीर मला परे पुनी आउ का पण नाती को जीवो अण नाती को जीवो कि पण नाती को जीवो आई कांट से दैट सो बेसिकली why unborn person फेवर रे जो ट्रांसफर ता एग्जीक्यूट होची सेटा एब्सोल्यूट होवा दरकार आउ लाइफ इंटरेस्ट जोडा अछंती तांको फेवर रे एब्सोल्यूट नै ताको फेवर रे आपण करछन तांको लाइफ पीरियड पर्यंत सेटा को ट्रांसफर कि तांको फेवर रहबो समान सती दिन एन्जॉय करिवे किंतु जते बेले अनबर्न पर्सन आसी गला इट मस्ट बी ट्रांसफर्ड टू हिज नेम एंड दैट मस्ट बी डन एब्सोल्यूटली से एब्सोल्यूट ट्रांसफर ताकू कहूची जे बार करूची आपण सेतेले करि परिबेनी जे ताकू न देई कि मु तार लाइफ परे मु अणनति को माने तार पुओ को देबी नो यू कांट डू सच थिंग that you must absolutely transfer the remaining interest that you have over the property after creating a life interest to the unborn person that you intend to so transfer. Essential गुडा कोन हमें जानिबा essential होची जे एठी डायरेक्ट ट्रांसफर होनी तो बेसिकली यू आर क्रिएटिंग ए ट्रस्ट ओटे आपण जण को कहउचली जहा जी आपण को पई होल्ड करिवो until that unborn person is coming to existence. So you can transfer till you can put a condition ki this property from today is transferred A shall hold it for life and then after A's son comes into existence it must be transferred to him absolutely. This is valid. But if you put a condition saying that this is transferred to A for life, then to A's son for life who is not born yet, and then to uh, A's son's son, no, that you can't do because hereby you are not transferring the absolute ownership, absolute interest to that unborn person. So this is what you must fulfill, that it cannot be a direct transfer, and the transfer that must be done to the unborn person, that must be done absolutely. That is, you can't attach any condition that here a life interest will be created for the unborn person and then to another person. You can't do such thing. Next essential is that you can transfer it to as many as interim persons possible. So I can transfer it to I can put a condition like this will be transferred to A for life, then B for life, then C for life, then D for life, then E who is not born yet, but that transfer to E must be absolute. So basically, the transfer that I propose to do, that must be in the following manner. That is, yes, and the fourth essential is that a final transfer must be absolute. I'll help you. I'll help you understanding the concept a bit more by transferring that if A wants to transfer a property to the ultimate beneficiary who is B, who is not born yet. So this person is not born. Basically, this person is not born, and you want to transfer a certain property to, this is the property that you want to transfer to B. While doing so, you have to transfer the whole interest absolutely. Here, the interest must be absolutely transferred. In the interim, you can appoint anyone for life holder, life interest holder. So you can appoint D, E, F, all of whom must be living at the time of transfer. So here A wants to transfer his property to B, who is an unborn person. Then he can appoint any persons in the interim and who will hold the property till their life. But if when you are transferring it to a person who is not in existence, that must be done absolutely. So DEF are persons who are in existence. DEF are persons who are in existence. So you can transfer you can transfer to them without giving them absolute interest. So basically you are by saying that it is being transferred to D for life, you are making sure that it is not transferred to him absolutely. So D ଯେତେବେଳେ ଆପଣ କହୁଛନ୍ତି ଯେ D hold କରିବ, D is not holding it absolutely. D ତାକୁ ମଲା ପରେ E କୁ ଦେବାକୁ ପଡିବ. E is also not holding it absolutely, ମାନେ ବିକି ପାରିବନି, ସିଏ ମଲା ପରେ F କୁ ଦେବାକୁ ପଡିବ. କିନ୍ତୁ ଯେତେବେଳେ F ରୁ ଆପଣ ଫାଇନାଲି ଆପଣ କହିଲେ କି ଯେ B ଯେ କି ଅନବର୍ନ ପର୍ସନ ଅଛି, ଆପଣଙ୍କ ପୁଅ କି ନାତି ଯେ ବି ଜନ୍ମ ହେଇନି ତାକୁ ଆପଣ ଟ୍ରାନ୍ସଫର କରୁଛନ୍ତି, ସେଇ ଇଣ୍ଟରେଷ୍ଟଟା ଆବସଲ୍ୟୁଟଲି ଦେବେ. ତାର ରିଜନ ଏଇଆ, ଯଦି ଆପଣ B କୁ ସପୋଜ ଏଠି ଆପଣ ଆବସଲ୍ୟୁଟ ନ ଦେଇକି this was transferred with for ଏମିତି D A F G H I J ଏମିତି ମୁଁ କରି କରି ଲାଷ୍ଟ କୁ ଚାଲିଥାନ୍ତି, ତାପରେ B କୁ ଏମିତି ଚଲେଇ ଚଲେଇ ଯାଇଥାନ୍ତି. ତ ଲାଷ୍ଟ କୁ ମୁଁ B କୁ ବି ସେୟା କହିଥାନ୍ତି ଯେ ତାପରେ ପୁଣି ଆସିବ ଆଉ ଗୋଟେ କୁ, that is be Z. So here I am making sure that my property is kept in abeyance, that ମୁଁ କାହାକୁ ମୁଁ ଦଉଛି କିନ୍ତୁ ନ ଦେଲା ଭଳିଆ. ଯଦି ଆପଣ free flow of property ନ ହବ, then it is not beneficial for anyone. ଓନରସିପ ର କିଛି ଭ୍ୟାଲୁ ରହିବନି. ଯଦି ମୁଁ ଦେଇଛି ଯୋଉ ଏଇ ଯୋଉ ଇଣ୍ଟରିମ୍ ରେ ଯୋଉ D E F G H I J K L M N O P ସମସ୍ତଙ୍କୁ ଦେଇ ସାରିଲେଣି, they are holding it but without enjoying the property because ସେମାନେ ଓନର ନୁହଁ, ତ ସେମାନେ ଚାହିଁବେନି ବି ସେ ପ୍ରପର୍ଟି କୁ ଡେଭଲପ କରିବା ପାଇଁ. So the property will not be developed. ଇକୋନୋମି ପାଇଁ ବି ଭଲ ନୁହଁ, because there will not be free flow of transfership. ସୋସାଇଟି ପାଇଁ ବି କିଛି ବେନିଫିସିଆଲ ନୁହଁ. ହାଉ? ବିକଜ ପ୍ରପର୍ଟିଟା ତ ଯିଏ ବି ହୋଲ୍ଡ କରିବ ସେ ତ କହିବ ହଁ ଆଫ୍ଟର ମାଇ ଡେଥ୍ ଇଟ୍ ଇଜ ଗୋଇଂ ଟୁ ସମନ୍, କାହିଁ ମୁଁ ତା ଉପରେ ଡେଭଲପ କରିବି. ସୋ ଇଟ୍ ଇଜ ନଟ୍ helping anyone. Government को help करिवनी किछ, because transfer जदि हबनी ताले how will they get revenue? So this rule 13 makes sure that free flow of transfer is maintained. And how it is done? By making sure that while you are transferring it to an unborn person, this rule is followed. I hope you are clear that these are the conditions you must fulfill when you are transferring a property to an unborn person. That is that no direct transfer can be done. It will be done through trust, and the reason is that the property cannot be kept in abeyance. No condition can be attached while you are transferring the property to the unborn person. That is, it must be transferred absolutely. So you can't basically create a life interest to the unborn person and then to another person. You can't do that. Obviously you can transfer to as many as intermediate persons, that means they can hold it for life, but all of them must be alive at the transfer. You can't say that A and then to A's son who is not in existence yet, because then it will be a transfer to unborn person only and it will be hit under this rule. So you will have to transfer all of the to persons who are in existence. Intermediate transfer ही कर ले. Main जो अपना absolute जो ultimate transfer है, that unborn person, ताकू अपना absolutely ले. That will make sure that rule 13 is followed at spirit. This is basically rule 13. It's not very complicated, though people tend to make it very complicated. It just says this much, that is that while transferring to an unborn person, you can transfer to as many intermediary life interests as possible, but all of them must be living. And then the final transfer to the ultimate transferee, who is the unborn person, it must be absolute. This is the right of unborn person. Now, rule of perpetuity. Rule of perpetuity is nothing but an exception to but not an exception, but a continuation to the rule that is enumerated under section 13. It is also an exception to the rule. It is also making sure that the property is not kept at abeyance and it is transferred from hand to hand freely. So that the reason is, the object of this rule again is to make sure that the property is not inalienable indefinitely. Making sure, it will make sure that it can be alienated at least at a time that you can predict. So what a predictable time भितर से property टा transfer हेत परथिया दरकार. अपन near future अपन जानी परिया दरकार. अपन calculate करिया दरकार कि okay, maybe it is 100 years, but say 100 years भी अपन definite period हुआ दरकार. So that गोटे लोक, the reason is very simple, that मु जदि जानी थी कि 100 years परे एटा absolute ownership काहु गोटे जीव और this person get, excuse me, so it can be developed or the person concerned will take interest in that property. So it is beneficial for everyone कि property टा air रे रोनी बहुत दिन पाई record holder माने कहाँ पाखु ultimately जीवो, you are knowing that. So this is what a rule of perpetuity intends to achieve. This is, as I told you, it is better for economy, owner, property, society. It is better for everyone. So it is a continuation of rule that is enumerated in section 13. So here you are basically, it is saying that to what extent or to what time limit a property can be kept in abeyance. So without transferring it actually to anyone, till what time you can postpone the vesting of that interest. So I believe it, the more proper name of this rule must be rule against the remoteness of vesting. So how far you can postpone the vesting of an absolute interest, that only this rule says. So here the rule says that there must be a transfer of property, and but why in that transfer of property no interest can be created in favor of an unborn person, which is to take effect after lifetime of one or more persons living and minority of that unborn person. Again, it is very, the words of this section is very complicated, but please be with me. I'll make it very easy. That is, here again, A wants to transfer the property to B, who is an unborn person. U means it is an unborn person. Here, while doing so, he will appoint many intermediaries such as D, E, F. So he can create, obviously, if you want to transfer it to an unborn person, you have to appoint and one, at least some person who will be holding it till the person is coming into existence. So you can't keep it in air. So you are creating that. So अपन DEF intermediate transfer कले. So this rule says that केते दिन पर्यंत अपन हेडा को abeyance रे रखी परिवे, that अपन transfer टा माने केते दिन पर्यंत ए जो vesting टा को अपन avoid करि परिवे. That ultimately transfer कला बेलकू केते दिन पर्यंत सेटा प्रॉपर्टी टा लाइफ इंटरेस्ट करी रख परिवे. Rule says that अपन lifetime of such intermediary person सेटा को सब जा काउंट हबो. सपोज अपन कले कि A to D को जीवो, D to E को जीवो, आउ A to F को जीवो, आउ F रू अल्टीमेटली B को जीवो जे कि अनबर्न पर्सन. सेठी आपण केते टाइम पर रखि परिबे D रो lifetime of D plus lifetime of E plus lifetime of F. Rule says it plus 80. That's the minority period of that unborn person. आपण जदि कहिबे जे मु unborn person को संगे संग ट्रांसफर न करी कि I want that he should get the property at the age of 18 years, max till 18 years you can avoid that. You can't put a condition that D ro life, E ro life, F ro life plus 100 plus B when he attends 23. No, you can't do that because this is violating the rule of perpetuity. So such a condition will be invalid and such transfer will be invalid per se, because hereby you are breaking the rule. So rule basically says that while you are creating creating an interest in favor of an unborn person, then the maximum period to which you can extend that remoteness of vesting is lifetime of the intermediary person who are living at the date of the transfer plus minority of the person who is not born yet. We'll discuss them more after discussing the essentials and breaking down the section 14. So section 14 says this much. What are the essentials of section 14? Section 14 says that there must be a transfer of property. So basically you are again transferring a property, and that transfer of property is for what purpose? That is for creating an interest in favor of an unborn person. But unborn person favor of interest create kariya pe apan transfer. Third is that the interest is to take effect after the lifetime of other persons and minority of such unborn person. ଆପଣ ସେ ଯୋଉ ଟ୍ରାନ୍ସଫର କରୁଛନ୍ତି ସେ ଯୋଉ ଇଣ୍ଟରମିଡିଆରୀ ଯେଉଁମାନେ ଅଛନ୍ତି ତାଙ୍କର ଲାଇଫ ଟାଇମ ପର୍ଯ୍ୟନ୍ତ ପ୍ଲସ୍ ମାଇନରିଟି ଅଫ ସଚ୍ ଅନବର୍ନ ପର୍ସନ ମାଇନରିଟି ୱାର୍ଡ ୟୁଜ ହେଇଛି 18 ଇୟର୍ସ କହିନାହାନ୍ତି ବଟ୍ ମାଇନରିଟି ମାନେ କେତେ 18 ଇୟର ହେଇଗଲେ ସେ ମେଜର ହେଇଗଲା ତେଣୁ ମାଇନରିଟି ପିରିୟଡ ଟା ହଉଛି 18 ଇୟର ଆଚିଭ୍ ହେଲା ପର୍ଯ୍ୟନ୍ତ ସୋ ଦ୍ୟାଟ୍ ମାଇନରିଟି ପିରିୟଡ ଟାକୁ ଆପଣ ମ୍ୟାକ୍ସିମମ୍ ସେତିକି ପର୍ଯ୍ୟନ୍ତ କରିପାରିବେ. And the fourth rule is that the unborn person must be born before the expiration of such last prior interest. So this rule again says that while you are transferring a property to B, I'm harping on this again and again because it tends to get confusing sometimes. But because if you keep it very simple, it will be clear. So you are here again willing to transfer this A property to B, and who is an unborn person. While transferring it, you are appointing D, E, and F as intermediaries. So the property can be kept in abeyance max till D plus lifetime of D plus lifetime of D, E, D plus E plus F plus the minority period of uh, uh, person who is not born yet. But there is one other condition that is attached, that the person B must come into existence before the death of the last intermediary person who is holding a life interest over it. So basically, before F's death, B must be born. So the B born hai before F's death, then this whole transfer that you intended to do will be void. Because then obviously the rule of perpetuity will be broken. Because right there, thereby you are making sure that the property is held for another time altogether. So you can't do such transfer, and only to the extent of life of the intermediaries plus 18 years you can keep the property at abeyance. This is the rule. But again a question comes that can the unborn person, ମାନେ ଗୋଟେ example ଆପଣଙ୍କୁ ଦଉଛି ଯେ what if the unborn person is not born before the last intermediary person, but he is in the womb of the mother. That means ସେ କନସିଭ୍ ହେଇଗଲାଣି, ଛୁଆଟା କନସିଭ୍ ହେଇଯାଇଛି। ସେଇ ଏକ୍ସାମ୍ପଲ ରେ କଣ ହେଲା, ଆଉ ଥରେ ଦ୍ୟାଟ୍ ଏ ଟ୍ରାନ୍ସଫର କରିବାକୁ ଚାହୁଁଛି ଯେତେବେଳେ ଗୋଟେ ଅଲ୍ଟିମେଟଲି ବି କୁ, ସେ ବି ଟା ଅନବର୍ନ ଅଛି, ଆପଣ ଏଠି ଡି ଇ ଏଫ୍ ତିନି ଜଣଙ୍କୁ ଦେଲେ, ବଟ୍ ଏ ଯୋଉ ବି ଟା ଦୋ ସେଥିରେ କଣ୍ଡିସନ ଏଇଆ ଥିଲା କି ଯେ ଏଫ୍ ର ଡେଥ୍ ହବା ଆଗରୁ ବିଫୋର ଏଫ୍ ଫଲ୍ସ ହୁ ଇଜ ଦି ଲାଷ୍ଟ ଲାଇଫ୍ ଇଣ୍ଟରେଷ୍ଟ ହୋଲ୍ଡର, ବି ମଷ୍ଟ ବି born. B ଏଠି born ହେଇନି, but B is in the mother's womb. B is in the mother's womb. So here, will it be hit by rule of perpetuity? The answer is no. Here, the gestation in India, the gestation period of the unborn person, that is taken as a grace period, and it will also be added to the period till which the vesting can be delayed. So, the ultimate answer to the question that till what time the property can be kept in abeyance or the vesting can be postponed is, as I told you, this is lifetime of all life interest holders. Lifetime of all life interest holders plus the gestation period if any. So for example, the if from ମଲା ଆଗରୁ ଯଦି ସେ ଜନ୍ମ ହେଇଯାଇଛି, then the gestation period ର question ବି ଆସୁନି। ଯଦି if ଯୋଉ ଲାଷ୍ଟ ଇଣ୍ଟରମିଡିଏଟ୍ ଯିଏ ଥିଲା ତାର ଡେଥ୍ ଆଗରୁ ଯଦି ସେ ଖାଲି born ହେଇନି but she has been conceived in the mother's womb, then in that case gestation period plus 18 years. ତ ତା ମାନେ କଣ ହେଲା, lifetime of life holders, life interest holders, plus period in which the child is in mother's womb, plus 18 years. This is the maximum time till this vesting of the property can be postponed. If you are putting any condition which is violating this rule, then that transfer will be void. So question comes again, there can be question like this in the exam, that A intends to transfer transfer a property to B for life, then C for life, then to D who is an unborn person till he when he attains the age of 25, or when he clears IS. This is also not valid because you don't know when will he clear IS. It can be either 18, either 25, either 30. You can't put a condition. But then this will be actually discussing under other things that we'll discuss later, that is contingent interest and vested interest. When we'll discuss that, we'll discuss it. Right now, you just remember that if a question comes that if A wants to transfer a property to to an unborn person, and hereby he is creating life interest, and he wants D to get the property when he attains 25 years, that will be void because this is against the rule of perpetuity. So the maximum period, again at the cost of repetition, I tell you that the maximum period till which the vesting can be postponed is this. This is very important. You just remember this, that vesting can be postponed till this lifetime of life interest holders plus gestation period if any plus 18 years. There is a slight change to the rule of 18 years in case of English law. That becomes 21 years. 21 years. English law re 21 years sele head habo. But 21 years ta bhi setre bhi out a clause 21 years tak bhi that can also be changed to any other period with a condition, that with a clause if they want to make in that instrument. Say transfer instrument re jodi se koibe je to another year when the unborn person achieves that age, say 21 years tak bhi change karibe. But amar ete that nahi mujhe kahiya pai kahili, but you must remember that only this much, that is while transferring it to an unborn person, ei tinta condition ko apanku fulfill kariyakku padibo in order to make sure that your transfer is not hit by the rule of perpetuity and hence falling in the eyes of law. This is rule against perpetuity. What are the exception of rule of perpetuity? Section 18 is an exception to the rule of perpetuity, which says that for the benefit of public and in advancement of religion, knowledge, health, commerce, etc., you can transfer a property beyond this rule that has been given in section 14. So, which says, so that means here, if you want to transfer a property to to a hospital, or you want to intend it to use it to be used as a hospital, and thereby you are breaking section 14, that is also, if you are breaking section 14, then also it is valid, because here section 18 says that for benefit of public and in advancement of religion, knowledge, health, commerce, etc., if you are breaking section 14 as well, then also the transfer will be deemed to be valid. Again, we have to know that to what the section 14 doesn't apply to. Basically, if you know that it is creating an interest, that automatically covers all this. That interest ଯେତେବେଳେ create କରୁଛନ୍ତି ଆପଣ, that means that ଏଇ ସବୁ ଜିନିଷ ଉପରେ ଆପଣ apply କରୁନାହାନ୍ତି। ସେ ଯୋଉ କହୁଛି କି ଯେ transfer create ହବ, କି interest create ହବ, that means କି ଏଇ ସବୁ ଜିନିଷ ଗୁଡ଼ା ଆପଣଙ୍କର automatically ଲାଗୁ ହବନି। କଣ କଣ? That it does not apply to vested interest. That means vested interest ଆମେ ପରେ ପଢିବା, that ଗୋଟେ interest ଯଦି already vest ହେଇଗଲାଣି, it cannot be divested. One, the rule is that once vested cannot be divested. So if there is a vested interest, then it will not apply to vested interest. Second is the property is given to individuals for memorable public services. ଗୋଟେ memorable public service କରିଛି, ତାକୁ ଯଦି suppose ଏବେ ଯୋଉ ଆଗରୁ ଦିଆଉଥିଲା ରାଜା ମାନେ ଦଉଥିଲେ ଗୋଟେ property କୁ ଧରି ପାରିବ ସେ ପୁରା indefinitely, ତା ଫ୍ୟାମିଲିରୁ ତା ଫ୍ୟାମିଲି, ତା ପୁଅରୁ ତା ପୁଅ, ତା ପୁଅରୁ ତା ପୁଅ, ଏମିତି କରି ଯାଉଛି। that was valid आसुला एबे भी जदी फॉर एग्जांपल के पद्मश्री पद्मभूषण की चला और गवर्नमेंट चाहिला कि ताकू एमती ट्रांसफर करिया चाहूची that they'll hold in their family for one after the other generation, that is valid. Clause of preemption, clause of preemption गोटे applicable आपण जदी गोटे clause of preemption रखिले preemption टा बेसिकली कोन preemption टा बेसिकली होची या दैट आपण मु ट्रांसफर करला को मु कोन करली मु गोटे क्लॉज रखिली जे ए जो प्रॉपर्टी टा मोर एक्स रो अछि तार फर्स्ट राइट ऑफ परचेज टा रहिबो मोर घरर शेयर घरर लोकंक पाखरे कि बी पाखरे फर्स्ट राइट परचेज टा रहिबो जेतले बी काहा को ट्रांसफर करिया को चाहूची काहा को तले ट्रांसफर करिया जीवो सेतले फर्स्ट परचेज टा रहि फर्स्ट परचेज राइट टा रहिबो सी पाखरे सी जदी काहा को ट्रांसफर करिया को चाहूची फर्स्ट परचेज टा रहिबो डी पाखरे एमती किछि गोटे कोवेनेंट रखली एमती किछि क्लॉज रखली दिस विल दो एठी भी होउची कि गोटे टाइप रे आपण को कहि परिबो कि जो ओके जदी इफ दैट प्रीएम्पशन इज फॉलोड देन प्रोबेबली it will be in the life माने in the family of a only जो जहा को से इंटेंड करथला to hold that property, but still then it will be a valid thing and say preemption condition को hit करिवनी rule 14 why because thereby दो फर्स्ट राइट अछि किछि माने नै कि से किनिबो कि माने नै कि जे बी सबले ही एक्स्ट्रा किनियो चाहिबो फर्स्ट राइट अछि बोली तार पैसा नथिबो कि कोड किनिबो और सी किनियो ता परे कि डी किनियो परे सेटा त नाही ना तो जोडी आपनकर डायरेक्टली रूल ऑफ अपॉर्चुनिटी किछि ब्रेक होनी तो इट इज फाइन कॉन्ट्रैक्ट फॉर सेल कॉन्ट्रैक्ट ऑफ सेल रे आपण किछि इंटरेस्ट क्रिएट करना यदि फुलफिलमेंट ऑफ एनी एक्शन गोटे आपण ताकू सेल करियो बोली कहछंती सेठी भी एटा हिट करिवनी कॉन्ट्रैक्ट फॉर परपेचुअल रिन्यूअल लीज लीज रे भी समती जदि तले देखिबे जदि गोटे ए गोटे लीज रे देबाकू जेतले दिए गोटे बी को जागाटा को लीज रे देछि सेठी कोन कहछि ना गोटे कंडीशन अछि ताकर जे से लीज टा रिन्यू हे चलिबो 99 इयर्स रे लीज करथिला तापरे आउथरे लीज कि वर्षिकिया लीज करथिला सेटा आउथरे लीज हे चलिबो माने रिन्यू हे चलिबो रिन्यू रो क्लॉज रखिला सेटा रिन्यू हे पूरा परपेचुइटी पर्यंत रखियो बोली सेइथरे किछ असुविधा नै कना से लीज दोउची लीज रे तो माने से ताको बिकिया को चाहुनी ना से रेंट हिसाब रे दोउची तो हियर ही इज नॉट willing to transfer it absolutely hence rule of perpetuity is not broken creation of charge if you are creating a charge over a property charge कोन charge होची चार्ज हमें पढिबा सेक्शन 100 जति पढिला पढिबा चार्ज कोन जे चार्ज होची गोटे प्रॉपर्टी ऊपरे आपण देयर इज एन एक्स प्रॉपर्टी ओवर व्हिच यू आर क्रिएटिंग ए चार्ज दैट तादरु जहा पैसा जनरेट हबो गोटे पेमेंट तादरु हबो सेंते किछ गोटे चार्ज होचंती दैट इज सेटा जति आपण इंडेफिनेटली गोटे चार्ज क्रिएट करले that will not be hit आपण कहबे कि जे सही तो इट्स गोटे इंटरेस्ट क्रिएट हे गला नो that will not be hit under rule against perpetuity. This is what that these are not be this will not be applied. Then again clause for redemption of mortgage same kotha eta bi mu कहली English law that 21 years instead of 18 and 21 years can again be changed by a clause in an instrument. सेक्शन 15 तापर आसिला सेक्शन 15 टा किछि नै सेया कहउची 13 14 रे जहा रूल कहउची सेही रूल को फॉलो कर माने सेही रूल पाई जदी गोटे इंटरेस्ट टा फेल करूची देन जदी गोटे सेटा ट्रांसफर टा गोटे क्लास ऑफ पर्सन्स को हेथिबो एंड से जो ट्रांसफर टा फेल करूची फॉर 13 एंड 14 दैट मस्ट बी इन फेवर ऑफ सम पर्सन्स देन इट विल टेक इफेक्ट फॉर द पर्सन्स अगेंस्ट whom it is not failing. तो आपण को ये करी मु बुझौची दैट आपण गोटे ट्रांसफर करचंती ए इज विलिंग टू ट्रांसफर दिस प्रॉपर्टी टू बी सी डी तो सेही जो बी सी डी तीनटा गोटे क्लास ऑफ पर्सन्स जो माने कि तीन जण होचंती अनबॉर्न सफर फॉर एग्जांपल तीन जण हे अनबॉर्न तीन जण को मु ट्रांसफर करिया चाहूची बट कहली एटा बी आ सी को मिलिबो जतले से माने 18 हेतिबे ये को जतले 16 हेतिबे डी को मिलिबो जतले 23 हेतिबो एठी डी एठी मु रखितली एक्स वाई जेड मोर थिला तो एठी मोर एक्स वाई जेड रो जो रूल टा लाइफ रूल हेटा तो किछि वायलेट हेलानी एठी 18 इयर्स पर्यंत मैक्स कहितला गोटे लोक 18 इयर्स अटेंड कला पर्यंत अनबन ता पर्यंत रखेबो एठी 16 ताकू वायलेट हेलानी बट डी रे आपण जतले 23 कर देले डी अगेंस्ट सेटा वायलेट हेगला सो 15 सेज दैट आपण क्लास ऑफ पर्सन्स को ट्रांसफर करिया चाहउचंती एंड गोटे अगेंस्ट सेटा वायलेट होची रूल 13 14 टा ताहेले ओनली अगेंस्ट द पर्सन्स जहार वायलेट होनी धरा जीवो कि तांकू ट्रांसफर हेची बी डी टा फेल हेला तो बेसिकली इट सेज कि ଯେ ଜଣଙ୍କର ଭୁଲ ପାଇଁ ଆଉ ଆପଣ ସମସ୍ତଙ୍କୁ ତ ପନିଶ କରିପାରିବେନି ନା। ତ ଜଷ୍ଟ ବିକଜ ଜଣକୁ ଟ୍ରାନ୍ସଫରଟା ଫେଲ କଲା that doesn't mean କି you will deem the entire transfer void. You only have to deem the transfer against the persons against whom rule 13 or section 14 or section 13 and the rules enumerated thereof have failed. So section 15 says that much only, that class of persons and interest against some persons fails for violation of section 13 and 14, then transfer fails in regard of such persons only, not against everyone. It will be deemed to fail against the persons who, for whom or against whom it has failed in for violation of section 13 and 14. Now coming to section 16, that is transfer to take effect on failure of prior interest. Basically, this rule again says that when will a transfer to take effect fail? If it when will be a transfer which has been scheduled to take effect fail on failure of prior interest? So basically, it is based on the English rule one more English rule that says that condition dependent on a void condition is also void. So basically, ଏଥିରେ କ'ଣ କହୁଛି ମାନେ ଆପଣ ଗୋଟେ transfer କରିବାକୁ ଚାହୁଁଛନ୍ତି and you are saying that it will take effect on failure of a prior condition. But a prior condition किंवा prior interest आपण create करचंती and only when it fails the transfer will take effect. And that condition or that interest must fail because it is in violation of section 13 and 14. Then that subsequent transfer must also fail. That means here you are trying to play a game with the law. So basically, what if the section 16 you are trying to be very smart and thereby willing to transfer that property to another person without actually making it seem like the persons you have not transferred, you did not intend to hurt them. So basically, let me give you an example. You will be more clear. Section 16 रे कौन कहବାକୁ ଚାହୁଁଛି exactly that a ଏଠି କଣ କରୁଛି ଗୋଟେ transfer ଟା କରିବାକୁ ଚାହୁଁଛି ultimately transfer ଗୋଟେ କରିବାକୁ ଚାହୁଁଛି e କୁ but ସେଠି e କୁ transfer କଲା ବେଳକୁ ଯଦି ସେ ଏ କୁ ଡାଇରେକ୍ଟଲି କରିଥାନ୍ତା ଏ କୁ କରିଥିଲେ ମେ ବି ତାକୁ କିଏ କହିଥାନ୍ତେ କି ଆରେ ତୁ ତାକୁ ହିଁ ଦେଇ ଦଉଛୁ ମତେ ଦଉନୁ କି ତାର କଣ ଯାହାବି ସେଟାକୁ ସେ ଲୁଚେଇବା ପାଇଁ କଣ କଲା ଏଠି ଗୋଟେ କଣ୍ଡିସନ ଏମିତି କଲା ଯେ ଏ ମୁଁ ଡି କୁ ଟ୍ରାନ୍ସଫର କରୁଛି କିନ୍ତୁ ଯଦି ଡି କୁ ଟ୍ରାନ୍ସଫର ନ ହେଇ ପାରିଲା ତାହେଲେ ସେଟା ଇ କୁ ଯିବ ଆଉ ଯୋଉ ଡି କୁ ଟ୍ରାନ୍ସଫର ନ ହେଇ ପାରିଲା ସେଇ କଣ୍ଡିସନ ରେ ଏମିତିଆ କଣ୍ଡିସନ ପୁଟ୍ କରି ଦଉଛି ଯେ x y z କୁ ଲାଇଫ ପ୍ଲସ୍ D କୁ ମିଳିବ ଯେତେବେଳେ he attains age of 24 years. So he made sure that the rule will be broken, the condition will be void. ये rule of perpetuity को break कला भलिया condition बनेइथिला से जो prior interest create करिछि and the condition that he has imposed that is itself breaking the rule against perpetuity. So if that does that, then say just because this prior condition failed, this transfer from D to E will not take effect. Why? Because he wanted to play a trick with the law by saying that on failure of a prior interest, this property will be transferred to another person. But the failure of prior interest is because of the reason that he violated section 14. You're getting it? Section 13 14 को intentionally मैं एमती condition को impose कली so that सेटा आपे आपे violate हबो मु जहा को चाहूतली transfer करिया को ही को सेटा automatically जेतु fall करी गला hit rule against perpetuity रे hit हे गला आ पळेला ही को. So I can't impose a condition saying that कि एमितिया prior interest यदि fail करिवो it will be transferred to you. Here you are imposing a condition which is void. So that condition you have imposed is void and a transfer which will happen on not happening of that condition will also be void. This is the simple rule which says which section 16 talks about this. Now we had already discussed section 18 probably, that is section 14 16 and 17 does not apply to charitable transfers, that is where you intend to transfer a property for the benefit of the public in advancement of religion, knowledge, commerce, safety, health, or any other beneficial object of the mankind. Then in section 14, section 16, section 17, will not be applicable. Section 17 we have not discussed. We'll discuss it tomorrow. If anyone has any doubt, they may raise it, or we shall mark the end of this lecture.
Sir, namaskar.
Namaskar, Rishi.
Sir, section 13 जो कहला ट्रांसफर फॉर बेनिफिट ऑफ अनबॉर्न पर्सन सर सेतरे धर आमे गोटे नेक्स्ट जनरेशन पई माने प्रॉपर ट्रांसफर करिया सपोज आपण जोडे बुझैले जे मु मो नाती पई करी तो ता पई आमे किछि लाइफ इंटरेस्ट जो रखिया माने जे इंटरमीडिएट जाई से मो पोई पारे या मोर पुत्रा भी पारे तो मो कहया कथा इफ मो पुओ मरी गला तब से जो इंटरेस्ट को होल्डर कर माने होल्ड कर देन सेटा कहा पाखु जीवन नेक्स्ट मो जहा को मु करूची धर मोर नाती जे अछि धर ताको पाइया पूर्व मो पुओ मरी गला
माने नाती पाइबा पूर्वरु मो पुओ मरी गला
हां से होल्ड करथला ना इंटरमीडिएट थला
तो सेट तो रूल 14 रे भी ब्रेक हे गला ना रूल 14 रे ब्रेक हलानी कि रूल 14 रे कहला इट मस्ट द अनबर्न पर्सन मस्ट कम इनटू एक्जिस्टेंस बिफोर द लाइफ टाइम ऑफ द पर्सन हु इज होल्डिंग इट त माने आपण पूरा ऑटोमेटिकली पुनी आउथरे पळे आसीबो का पाकू ओरिजिनल होल्डर पाकू
ओ सर ऑटो रिटर्न आसीबो आउथरे
यस बिकॉज़ एटी आपण तो ब्रेक हे गला ना जो रूल टाइम कहूची सेटा तो ब्रेक हे गला दैट द अनबर्न पर्सन इज नॉट कमिंग इनटू एक्जिस्टेंस बिफोर द डेथ ऑफ द होल्डर हु इज होल्डिंग इट फॉर लाइफ
यस सर
getting it
thank you sir thank you
yes so the rule is that आपण जत्तेटा इंटरमीडिएट पर्सन्स रखछन्ती रखन बट अनबर्न पर्सन टा बॉर्न हिजवा दरकार बिफोर द डेथ ऑफ द लास्ट इंटरमीडिएट आ सेतिको जो इंटरमीडिएट आपण रखछन्ती समस्ते से ट्रांसफर टाइम रे लिविंग होवा दरकार आपण जदी अनलिविंग पर्सन को माने मझिरे एमते लाइफ इंटरेस्ट क्रिएट कर परिबेनी जो माने एक्जिस्टेंस रे ना ताल त आपण एटा पुनी आउथरे आपण अबेंस को रखि देले जे काहा को एक्जेक्टली मु ट्रांसफर करछि जानि तो बेसिकली मु कहि देबी जदी ए को तापरे ए रो नाती को नाती ए रो नाती जेकी जन्म हेनी सेम ताकू लाइफ इंटरेस्ट देकी मु पुनी सी को दे परिबी दैट कैन नॉट बी डन
ओके सर थैंक यू
एनीवन हैज अदर डाउट अभिप्सा प्लीज आस्क
yes sir namaskar
नमस्कार
sir same question ta ki कहले sir जदि से केस से गोटे कंडीशन अछि कि the unborn has to attain the age of 18 जोटा हमें पढ़ना suppose the unborn is 12 years old and the last one in whom the life interest was vested upon he dies then say केस से कौन होबो
कौन मैं एक्चुअली क्वेश्चन बुझ पल्ली कैन यू रिपीट इट अगेन
sure sir 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 I don't know my voice does it
yes no टिके इको होची बट you may say
okay sir sir मोर क्वेश्चन होची कि जन लास्ट से पहले कि the last person on whom the life interest is vested upon जति ताकर डेथ हो जाउची and the unborn person is already has already come into existence but city condition अछि कि ताको 18 years रो ही property का transfer but he is not of 18 years 12 years रो अछि and the last person on whom the life interest was vested upon he is dying तो सर सी केस में कौन हबो
अगेन मो लास्ट पार्ट नहीं सुनी परनी इको टिके होची
सर आपण टिके म्यूट कर दियन आई गेस ताहे
ओके
सर इज इट ऑडिबल नाउ हां यस सर मु लास्ट रे यही कहूची कि जदी कंडीशन ता अप्लाई हिची कि अनबॉर्न पर्सन को 18 इयर्स अटेंड करिवार अछि सो दैट द प्रॉपर्टी इज ट्रांसफर्ड टू हिम बट अनबॉर्न पर्सन ता एक्जिस्टेंस को आसी जाउची बट ताको 18 इयर्स हेइन से 12 इयर्स रे अछि आ लास्ट लोकटा माने जहा ऊपर लाइफ इंटरेस्ट ता वेस्ट हेची सपोज द पर्सन इज ई तो सी लोकटार डेथ हे जाउची बट ए लोकटा माने 18 इयर्स रो हेनी माने अनबॉर्न पर्सन ता 12 इयर्स रे अछि तो सर सी केस रे कोन हबो सर एठी चेन ता ब्रेक हबो ना कोन सर यू आर ऑन म्यूट
the condition was that only that he'll be getting the property at the time when he is attends 18 so ता गुरु से मरी गलानी तो that means he that but yes ये the exception to the rule that 80 vested interest create he gala Yes, you asked a good question. ମୁଁ ଏଟାକୁ ଭୁଲି ଯାଇଥିଲି ଆପଣଙ୍କୁ ଏକ୍ସେପସନ ରେ କହିବାକୁ that ଏଠି vested interest create ହେଇଗଲା ଥରେ born ଯେତେବେଳେ ହେଇଗଲା vested interest create ହେଇଗଲା so that here the at the time of birth ସେଠି ସେ 18 years ତାକୁ ହବ ହିଁ ହବ ନା ଆପଣ ବୁଝିପାରୁଛନ୍ତି ମୁଁ ତ ଥରେ ଜନ୍ମ ହେଲା ପରେ 18 years ତାକୁ ହବ
हाँ
तो he will get that property.
और जदि सर 15 इयर्स रे डेथ ହେଇଯାଉଛି ତାହେଲେ
this is a very tricky part ଯଦି ସେ 15 years ରେ death ହେଇଗଲା then it is a different but I believe vested interest should come into the picture because he
सर
is
सेक्शन 20 ରେ ଦେଇଛି ତ ସେକ୍शन 20 ରେ ଯେମିତି ଜନ୍ମ ନଉଛି ସେ ବେସିକ୍ କ୍ରିଏଟ୍ ହେଇଯାଉଛି ତ ସେ
that is
18
what I'm saying कि ଯଦି ଆପଣ ट्रांसफर କରୁଛନ୍ତି vested interest create ହେଇଯାଉଛି but her question is again changed which is very tricky again that what if he dies at the age of 15.
ତାର ଇଲିଗାଲ ଏକ୍ଟ ମାନେ ପାଇବ ବେଷ୍ଟ ହେଇଗଲା
Yes, I believe that should be the way because vested heigala pore I don't think it will be divested again. That once he is born, he becomes the person who has a vested interest over that property. If he dies, then his heirs should come into picture. But निश्चित question ଥିଲା कि से यदि born ही हेलानी ताले तो सेठी आपण vested interest अपन तो create ही
गॉट इट सर
okay so these are
ସାର୍ ସାର୍
basic
ସାର୍ ଏଇ କ୍ୱେଶ୍ଚନରେ ମୁଁ ଟିକେ ଗୋଟେ ଜିନିଷ ମୋର ବି ଡାଉଟ୍ ହଉଛି ସାର୍ ସେ କହିଲେ ଯେ ଯୋଉ 15 ବର୍ଷରେ ସେ ମରିଗଲା ଯାହାକୁ ପ୍ରପର୍ଟି ଦିଆହଉଥିଲା ବେଷ୍ଟ ହଉଥିଲା ଆପଣ କହିଲେ ସାର୍ ଯେ ତାର ହେୟାର ଯେ ସେ ପାଇବ ସାର୍ ଇଫ୍ ତାର ପ୍ରପର୍ଟି ଯୋଉ ମାନେ ଆଉ ଥରେ ଅରିଜିନାଲ ଯେ ଦେଇଥିଲା ତା ପାଖକୁ ପଳେଇ ଆସିବ
କୋଡା ପଳେଇ ଆସିବ
ହଁ ଧର ମୁଁ ଦେଇଥିଲି ମୋ ନାତିକୁ
ବଟ୍ ସେଠି ତ ମୁଁ ତ ସେଇଠି ଟିକେ ବି ମୁଁ ବି actually confuse ହଉଛି ଯେହେତୁ vested interest ଥରେ create ହେଇଗଲା will it be
ଆଜ୍ଞା
divested will he be divested again of that vesting that has been done
Sir,
section
sir, I attended one classes
yes
and on
ekta has to say something about this
and in classes in coaching classes, sir dictated on notes that if before majority transfer or intermediary both die, then condition void, transfer void, property shall go back to transfer or his legal representative.
so if so in this case if he attends 15 and he dies then the transfer will be void once again
Yes, sir. As per the notes I've written.
okay I
यस
don't know
सर
my
सर
yes
लीगल एयर का
Abhisha
था
also Abhisha also thinks that I think
ସାର୍ ଲିଗାଲ ଏୟାର ନଥିଲେ ମୁଁ ପ୍ରୋବାବଲି ଭାବୁଛି ସେଟା ଅରିଜିନାଲ ଟ୍ରାନ୍ସଫରକୁ ହିଁ ରିଟର୍ନ ଆସିବ
ଲିଗାଲ ଏୟାର ତ ନଥିଲେ ତ ଆସିବ ବଟ୍ what if ତାର ଲିଗାଲ ଏୟାର ଥିଲେ ବି ଆସିବ କି ନାହିଁ
ସାର୍ ତାର ଏତେ ଟିକେ ପ୍ରୋଭିଜନ ସେମିତି ଅଛି ଆମେ ତ କ୍ଲିୟର ନୁହଁ ସେ ବିଷୟରେ
section 20 just says one thing section 20
ସେଟା
just says
ଆମ୍ବିଗୁଇଟି ରହିଯାଉଛି ସାର୍ ଗୋଟେ
it is an ambiguity it is a clear case of ambiguity that
ଯଦି
what does
ଡିସାଇଡେଡ୍ କେସ୍ ନଥିବ ଦେନ୍ ଜାଣି ହବ ସାର୍ ନହେଲେ ଜାଣି ହବନି ଏକ୍ସାକ୍ଟ
exactly but I don't think well, let me find out more about this
ଓକେ
but
ସାର୍ ଓକେ ସାର୍
ekta also said that ତାଙ୍କ coaching ରେ କୋଠି କୁହା ହେଇଛି if you do not mind can you elaborate which coaching was it Astush sir
Yes, sir. It is reputed coaching in
I know
Jaipur,
oh Jaipur
JKILS,
acha.
JKILS Institute.
Okay so they have said that if on if the unborn person does not attend the majority period if it has been prescribed then the transfer will fail
Yes, sir. Because this was the condition
you please
given.
ask them this question that if the property has been vested can it be divested once again
Sir, according to them, it is not vested because there is a condition, and condition is void. Condition goes void, so transfer gets void.
see but see the wait what is the exception wait where is the exception where it is yes section 20 says that where on a transfer of property and interest therein is created for the benefit of a person not then living he acquires upon his birth unless a contrary intention appears from the terms of the transfer a vested interest although he may not be entitled to the enjoyment thereof immediately on his birth so that means you are again postponing it for 18 years or more, you can postpone it, but he is getting a vested interest over it. So the rule says that if it is vested, can it be divested once again? Again, anyway, I'll get back to you. I'll get back to you on this as well. This is a very good question. We had a very fruitful discussion. So there are three circumstances that may arise here. That is what first is, as Nishit
Oh,
told.
sorry, sir. I would like to interrupt.
Yes, please say.
Section 20 says when property is transferred, it is not yet transferred because the condition got transfer got void. So it is not yet vested on the
No. It doesn't say that. It says that where on a transfer of property, you are again transferring a property. The words of section 13 is also that. The words of section 13 is also where on a transfer of property. So you will say here transfer has not taken place. No, you can't say that.
Okay, sir. I'll
Sir,
see
this
once again.
transfer probably may not be void.
What is it?
Sir, this transfer probably may not be void.
I also believe the same, that
Because
this transfer.
the provision section 13 and section 14 clearly states about the transfer for benefit of an unborn person. How can it be void, sir?
Absolutely, I also feel the same. But then, as we discussed, there is a reputed coaching in Jaipur which says otherwise, that it can be divested because the condition that he must have fulfilled before he attained majority was not fulfilled here, and that's why it will be divested and it will go to the original owner. So they are saying that I'll get back to you on this. I'll get a clarity and I'll get back to you on this. That whether we have one
Okay, sir.
doubt
Thank you,
only.
sir. Thank you, sir.
We have only one doubt, that is that ଆଉ ଯାହାକୁ ବାକି ଜିନିଷ ତ କ୍ଲିୟର ହେଇଗଲା ଯେ ଯଦି ବର୍ନ ହେଇନଥିବ କଣ ହବ, ସେ 18 years ହବା ଆଗରୁ ଯଦି ମରିଗଲା, then what will happen? What if he dies at before the age of 18, which was originally intended by the owner to be transferred to that unborn person ultimately? What if that condition is broken? What will happen? Whether it will be vested, whether it will remain to be vested because he was born and the interest therein with the unborn person has been created, or it will not be done. So we'll get back to you on this. Again, ଆଉ କିଛି question ଅଛି, or anyone else has any other question? So this is okay. Trinath has a question. Please ask.
सर नमस्कार सर
Namaskar.
सर जो अनबॉर्न पर्सन को जो ट्रांसफर हबो केतेटा अनबॉर्न पर्सन को ट्रांसफर ही परियो
जो कही ना क्लास ऑफ पर्सन्स रे आपण राइट जो सेक्शन 15 रे कहूची क्लास ऑफ पर्सन्स को ट्रांसफर कर दियो, त आपण बहुत गुडा अनबॉर्न पर्सन को भी एक संगे ट्रांसफर करिवे. दैट इज सेठी कोडी कोहनी कि जे आपण गोटे ही अनबॉर्न पर्सन को ट्रांसफर कर परिवे. आपण अनबॉर्न पर्सन रो क्लास को भी चाहिए जदी ट्रांसफर कर परिवे. Because you hereby it is saying that if on a transfer of property and interest therein is created for the benefit of a class of persons, with regard to some of whom such interest fails by reason of any of the rules contained in section 13 and 14, such interest fails in regard to those persons only and not in regard to the whole class. That only means that you can transfer it to a class of person and not only one person. But
सर
all of
क्लास
such.
सर कही हबन ना जे क्लास जो क्लास ऑफ अनबॉर्न पर्सन को हमें ट्रांसफर करिए चाहूतु समस्त एट ए टाइम बॉर्न हेबे बोली
हाँ
तो कि आगो पछे भी पारे
यही पर तो सतर लिखिथिबो ना कंडीशन कि आइदर ये माने एट द एज ऑफ अटेंडिंग 18 you will get. Suppose I am putting a condition saying that I am transferring this property to A for life, then B for life, and then B's children. Absolutely. So if I am doing so, I am transferring it to the unborn person of B. That is not a void condition that I can do. But jaha bhi ho, it must fulfill the rule that has been enumerated in section 13 and 14. That first is that you have to transfer it absolutely to the unborn person. Second is that you must create life interest holders, all of whom must be living at the time of the transfer. Third is that can be postponed only for till the lifetime of such life holders plus 18 years or plus gestation period, if any. Only till that period you can transfer. If all of these are followed, I don't think there is a bar in law which prohibits you to transfer it to a class of unborn persons. Okay.
ମାନେ ସେଟା ତଥାପି ଟିକେ ଡାଉଟ୍ ରହୁଛି ଯେ ଯଦି ଗୋଟେ ଅନବର୍ନ ପର୍ସନ କୁ ମାନେ ଧର ତିନିଟା ଅନବର୍ନ ପର୍ସନ ଅଛନ୍ତି
ହୁଁ
ତ ଧର ଏ କୁ ଏ ଜନ୍ମ ହେଇଗଲା
ହୁଁ
ତ ତାର 2 ବର୍ଷ ପରେ ବି ହବ।
ତ କଣ ଅସୁବିଧା ଅଛି? ଦି ବର୍ଷ ପରେ ବି ର ଇଣ୍ଟରେଷ୍ଟ କ୍ରିଏଟ ହଉ, କଣ ଅସୁବିଧା ହେଇଯାଉଛି? ଏକା ସାଙ୍ଗରେ ଟ୍ରାନ୍ସଫରଟା ଇଫେକ୍ଟ କରିବ ବୋଲି ତ କିଛି ମାନେ ନାହିଁ।
ଆବସୋଲ୍ୟୁଟ ଇଣ୍ଟରେଷ୍ଟ ଟା ପଳାଏ ନା, ତ ଆବସୋଲ୍ୟୁଟ
ଆବସୋଲ୍ୟୁଟ ଇଣ୍ଟରେଷ୍ଟ କେମିତି ପଳେଇବ? ଯଦି ମୁଁ ଏ ବି ସି ତିନି ଜଣଙ୍କୁ ଫେଭର କରିଛି, ଆବସୋଲ୍ୟୁଟ ଇଣ୍ଟରେଷ୍ଟ ଏ କୁ ଖାଲି କେମିତି ପଳେଇବ?
ସେ ତ
He may enjoy it. He may enjoy it till that. But obviously, ମୁଁ ତିନି ଜଣଙ୍କୁ unborn person କରିବି, I think I can do it. But then that will जो ଏଇ जो this rule that I said, that ସେଇଟା 18 years of the first unborn person, that must be applied. You getting it?
ଆଚ୍ଛା
Because again, it's a very tricky question again. That if I'm transferring to my class of unborn person, that is fine. But it cannot be again kept in abeyance कि 18 years ପରେ ବି ଆଉ ଥରେ property ଟା abeyance ରେ ରହିବ, that I can't do. So 18 years ପର୍ଯ୍ୟନ୍ତ ମୁଁ abeyance ରଖିପାରୁଛି, ମାନେ x for life plus y plus life plus z ର life plus 18 years. ତ first unborn person ର 18 years. And anyway, it is a hypothetical question, so I am giving a hypothetical answer anyway. That whether to a class of unborn persons it can be transferred, I believe it is. Yes, it can be transferred to a class of unborn persons as well.
ଠିକ ଅଛି ଥ୍ୟାଙ୍କ ୟୁ।
Okay. So anyone else has any doubt, or will end the discussion today? Yes, Abhishek.
Sir, so then in that case, there will be a time in which the property will be enjoyed by two persons at a time, like এটা जो କହିଲେ the last class of unborn person ଯଦି transfer ହଉଛି,
हाँ, तो फिर कौन है?
ସେମାନେ ମୁଁ କହୁଛି at a time ଗୋଟେ property କୁ ଦି ଜଣ enjoy କରିପାରିବେ, absolute interest ଟା ଦି ଜଣଙ୍କର ରହିବ property ରେ। Is it
unborn person ଦି ଜଣଙ୍କର? हाँ, it is fine. Rule doesn't say, rule 13 rule 13 does it say that it cannot be transferred to more than one unborn person? ମୁଁ children को तो करी परिए ना. I think there is no bar in law, though it does not necessarily say about transferring to a class of unborn person, but there is no bar in law. So if I am not violating section 13 and 14 and I want to transfer it to a class of unborn persons, that is fine. But the rule that is enumerated in section 13 14, the TK is, there cannot be any lenient departure from that. You have to follow it strictly. Rule 13 and 14, if they are followed, if you are transferring to a class of one person also, and it is absolutely created, if the absolute interest is created in favor of such class of unborn persons, then that is fine.
yes,
Sir, there
Yes.
is a doctrine of double possibility.
That is,
So, according to double possibility, you cannot select to have two possibilities. You can only have one possibility where you are transferring to unborn child. Unborn child is not yet born, has possibility. So you cannot have two possibilities. For example, there are two cases.
yes,
You cannot say that I will transfer to unborn child who is not yours unborn child. So you are giving two possibility. One, the child is already one possibility. Second is you are saying that that child will be a daughter. So that is the second possibility you are saying. So double possibility.
yes, but we are not going to that. We are not
Sir,
going to
now
that.
I'm saying double possibility. So the second case says that you cannot have two unborn childs because one unborn child is already one possibility. So another unborn child goes to double possibility. That is also prevented by Indian law.
Okay. Can you just send me that rule, because I was not aware of it. I just interpreted
Yes,
section
sir.
13 and 14, and I believed that probably it cannot be, there is no bar in law to transfer it to a class of one person. But if you're saying that
Sure, sir.
there is this rule, again, we can't break the double possibility rule, then you please
Yes,
send that.
sir.
I'll go through that.
Sure.
Okay. Pratyasha has a question.
सर जो क्वेश्चनटा पचारथिले अभिप्सा
Mhm.
सर सेतिरे कहिसंती कि से जो 18 इयर्स पूर्वरु जदि तांका डेथ हे जाउची
Hmm.
सर आपण कहले कि सेतिरे गोटे वेस्टेड इंटरेस्ट तापरे थाए माइनर उपरे
Hmm.
सर मु गोटे जागारे किंतु बुक रे पढिची कि सेटा मु एक्चुअली बहुत कंफ्यूजन रे अछि सेठी कंटिजेंट इंटरेस्ट लिखाइची
ଲେଖା ଅଛି contingent interest ଅଛି।
आज्ञा सर सेठी कुहाइची कि जे पर्यंत 18 इयर्स ताको न हेची से पर्यंत ता पाखरे
There is a
कंटिजेंट इंटरेस्ट
possibility that
अछि
he'll die before attends 18, no?
आज्ञा सर और सेठी
Again,
लिखाइची
again on further, actually, when I was actually thinking it again, the section 20 ରେ ଯେତେବେଳେ କହିଲା, when section 20 is talking about the fact that where on a transfer of property and interest in there is created for benefit of a person not then living, he acquires upon his birth unless a contrary intention. So if we actually interpret that if the contrary intention here is that he'll get the property at the age of 18. So here this rule will not be applied because you are putting a condition that he will get the property only at the age of 18. So there is a possibility that he might not get the property because he will die before he attains 18. So in that case, I believe this vested interest rule shouldn't be applied. Yes, you're right.
सर आउ गोटे भी सेठी लिखाइची से पर्टिकुलर पैराग्राफ रे कि जदि से एक्चुअली 18 इयर्स पूर्व मरि जाउची देन सेही प्रॉपर्टीटा रिवर्ट बैक हे जिवो टू द ट्रांसफरर
Yes,
आ
if
जदि
there is no
ट्रांसफर मरि
vested interest, then it will revert back.
आज्ञा सर जदि तापर कहूची कि ट्रांसफर को हे जिवो जदि ट्रांसफरर भी मरि जाइची तार एड्स को ट्रांसफर हे जिवो
Transfer मरि ताले तांको heirs को transfer हे
तांको
Yes.
एड्स
Okay.
आज्ञा सर
So basically, it should have been very simple. I shouldn't have thought about this vested interest condition altogether, because when Nishit asked that if he died before the unborn person was born, yes, will the transfer be void? Yes, it will be void because it is breaking it. Then Abhiksha asked that whether it will be valid at the age of after because he died before he attains 18. That should have been the answer as well. That yes, it will be void because he could not attain the age of 18, because the condition was that. I was originally answering that, but then somehow I got stuck with section 20 because it says this vested interest thing. But then it is true that because section 20 talks about the fact that unless a contrary intention appears from the terms of the transfer, so the terms of the transfer, it says that he will get the property at the age of 18, and now it is not being complied because he had died at the age of 15. Then the transfer should be void and he should uh, revert back. As Ekta told in her coaching also, it was mentioned that because the transferee died, the transfer would be void. The ultimate transferee died without attaining majority, so the transfer will be void and it will be reverted back to the original owner. I think that was the origin. That was the answer I should have given. And it
Sir,
is yes.
I once again read the same sentence.
Mhm.
It says that transfer or intermediary died, not transferee.
So you're again backing from your own word now.
No, actually, I read it this way only, but I presume transfer to be transferee. I was reading transfer, transferee,
So that was never the
but I
case.
think that
That was not a disputed case anyway. So it was
yes,
very
sir.
clear that they will die. If they die, the obviously the
It will go
interest
back.
will not sustain. It will go back. The question
It will
here
go
was
back.
whether the transferee, the ultimate transferee that we intend to transfer, if he dies, what will happen? But I believe if
I
even if
think
they have not written, even if it was not written transferee, let's presume, and we have to stick it to that if it the condition that has been put in the transfer, if that fails for any reason whatsoever, transferee died, still then the condition is failing. Here only he has a contingent interest, and contingent interest, it will come back to the original owner. I had an interest, I could have gotten it if I had attended the age of majority, but that I couldn't get it. So if the enjoyment was postponed, that is fine, but you are not postponing the enjoyment. You are actually making sure that he'll get the property at the age of 18. So here, even if the transferee dies, I believe the property will
yes,
come
sir.
back to the original owner.
Yes, sir.
yes
Okay,
sir
so we are basically clear in this aspect that transferor intermediary dies, it will fail. Transferee dies before transferee dies before he attended the age of majority or the age condition that has been put in the transfer, that will be holding the transfer void. If the unborn person was not born before the last holder of life interest died, then also the transfer will be void. If any of the conditions that are enumerated in section 13 and 14 they are not fulfilled, then also the transfer will be void. So I think this completes our fruitful discussion on 13 and 14. I also learned, I always keep telling you that I will learn something from you, and this is the day you proved me that yes, there will be times that it will be there will be a confusing section, and it will only be possible to clarify it along with the cumulative efforts that we put in. So I'm happy that you actually think like that. You have a curious mind, and that is only required in order to study law. If you have a curious mind, I think the half of the job is done. Rest you'll be taken care of anyway. Okay, so thank you for this discussion. I'll end the session here. Okay, thank you.